Dobar dan, pozdrav svima. Ja sam Tim Težak, odvjetnik iz Hanžeković partneri, riječ je jedan od partnera tamo. I evo, zamolili su me i pozvali da danas održim kratko predavanje o SAFE-u, dakle jednom od instrumenta kojim se može ostvariti financiranje u ranoj fazi startupa. Pripremio sam prezentaciju na engleskom, ali s obzirom da pričam na hrvatskom, onda ću se malo prebacivati hrvatski i engleski, ako neko ima nekih pitanja ili nejasnoća, neka kaže. Prvo jedan uvod koji sam doduše napravio na zadnjem predavanju o term sheetu, ali možda je koristan, a to je zašto uopće pričamo o boring legal stuff, odnosno stvarima koje većina foundera izbjegava dogod može i kako može, pa zato što kod investiranja se događaju neke promjene u vašoj kompaniji, govorim sad za foundere prvenstveno, i to investiranje može dovesti do promjena koje na neki način mogu biti irreverzibilne. Dakle, kad ste radili nešto s nekim potpisali, pustili ste nekog drugog u vaše društvo i morate se ponašati prema određenim pravilima koja ste pritom uveli. I drugo, dakle, investicije u nekim situacijama, kako reći, možete vratiti, odnosno isplatiti ulagača, ali u većini slučajeva ne. Znači, to su ljudi koji će ostati u vašoj kompaniji s vama kroz daljnje faze razvoja, pa bi bilo dobro da se s njima možete izaći na kraj, da je to nešto pozitivno. Tu sam crtao to je malo kao aparat za gašenje požara, ne morate ga imati prije nego što izbije požar. Dakle, pravne stvari ipak, koliko god bile grozne i naporne i nekad skupe, obično je bolje napraviti preventivno nego prekasno. Još malo o samim investicijama, znači iz pozicije foundera i startupa u ranoj fazi. Dakle, investicija nije samo novac, iako je to naravno prvi i glavni motivator founderima da to traže, nego tu su još neke stvari koje sam ovako probao malo pamtljivo nazvati circle, odnosno control, information, reputation, culture, legal obligations i expectations. Dakle, o čem se radi? To je ovako tu malo zgodno, jasno nacrtano, ali control, znači pitanje je ko upravlja društvom. Znači, pojedine vrste investicija, pojedini instrumenti daju investitorima pravo da suodlučuju, odnosno da utječu, glasaju, odnosno mogu zajedno s vama odlučivati o nečem što vaša kompanija radi. Information znači da ste isto tako pojedinim klasama investitora ili pojedinim ljudima koji drže određene instrumente dužni otkriti pojedine informacije o poslovanju, izvještavati ih i na neki način moraju znati šta radite jer su vam poklonili povjerenje i dali novac da bi vi nešto razvijali. Pitanje reputation je zapravo koga puštate u kompaniju, tu je u ranoj fazi bitno da su to ljudi koji će vam naravno pomoć svojim i ugledom i znanjem i ako treba nekim vezama, savjetima i to. Kasnije reputation isto znači da kad ulaze neki institucionalni investitori da je to netko ko je usklađen sa vizijom koju vi imate, dakle ako ste neko koji je jako sustainable, da taj fond onda bude neko ko podržava slične teme i politike. Culture je pitanje zapravo načina vođenja društva, komunikacije unutar društva i koje vrijednosti znači investitor donosi, odnosno na koji način će utjecati ili promijeniti ono kako se vi unutar društva obhodite jedni sa drugima. Mislim, to je ponekad bitno jer pojedini investitori, individualci znaju imati dosta veliki ego i znaju dosta htjeti vam pomoći, ali znaju pritom biti možda agresivniji nego što vi founderi htjeli. Imamo legal obligations, dakle ovaj dio koji reći nas pravnike najviše zanima, to je da u principu nema besplatnog novca. Ako nije friends and family, u principu svako ko vam pokloni povjerenje i da nešto novca će očekivati nekakva, odnosno potpisat ćete neka pravila igre kojima će se dalje taj novac upravljati i eventualno u jednom trenutku vratiti investitoru. I naravno expectations, a to je šta tko očekuje iz tog odnosa, šta očekuju founderi i šta žele da investitor osim novca kaže ili napravi i koliko zapravo investitori utječu ili ponekad i vrše možda pritisak na foundere da u određenom roku nešto napravi. Sad kako se tu uklapa SAFE? Dakle, SAFE je jedan od modernih, ajmo reći, načina, službeno ga izmislio Y Combinator pre 10 godina, načina ulaganja u start-upove koji je htio, odnosno zamišljen je sa idejom da ubrza i olakša tu cijelu proceduru, da bude standardiziran i da bude zapravo nekakav one-stop shop za investicije u ranoj fazi. Kratica SAFE je Simple Agreement for Future Equity, odnosno jednostavni ugovor za buduće udjele u društvu ili kapitala ako hoćete. Zašto se tako zove? Simple jer bi trebao biti less complicated od nekih tradicionalnih instrumenta kao što su convertible notes, odnosno trebaju biti standardizirani i jednoobrazan, pa samo nekoliko informacija ispunite i imate gotov dokument. Agreement znači ipak stvara određene obveze, nije samo proizvoljno. Future znači da ima neki budući trenutak kada će biti realizirano, odnosno da inicijalno za vas kao foundere ne stvara neke pretjerane promjene. I equity znači da se odnosi na udjele u društvu kada će oni biti u toj sljedećoj rundi izdani. Is it safe? Dakle, da li je on zato siguran ili da li je rješenje svih problema? Pa ovisi, mislim, kao i sve pravo može biti jako dobro, jako loše. Zašto ga, ajmo reći, na neki način hoćemo preporučiti ili zašto je izmišljen? Pa zato jer je relativno dobar investicijski alat, znači u toj ranoj fazi, jer ima manje stvari o kojima morate odlučiti, zapravo manje stvari koje morate znati u tom trenutku. Manje ga se treba pregovarati nego recimo prošli convertible note ili nekakav još složeniji instrument investicija. Nije dug, znači računovodstveno ne smatra se dugom, nemate obvezu ga novčano platiti kao recimo konvertibilni zajam koji je ipak zajam i koji bi trebali vratiti u novcu, ako se naravno svi nadaju da će ga vratiti konverzijom u kapital. Što znači da nema dospjeća, znači nemate taj vremenski pritisak da ga u jednom trenutku morate produžiti ako vam se produžila, odnosno rastegla priča sa razvojem. Nema kamate, znači da investitor njegov iznos koji uložio se neće povećavati s vremenom kao kod recimo konvertibilnog zajma koji ima u pravilu neku kamatu koja se pribraja glavnici i onda se konvertira glavnica plus kamata. I ja sam tu stavio more breathing space, dakle to bi vama kao founderima trebalo dati više, odnosno manje brige, a više prostora da u miru razvijete ideju i dočekate sljedeću rundu financiranja. No need to have valuation, dakle ne morate procijeniti, ne morate ići na procjenu kompanije u toj fazi, što je super jer vam uštedi dosta brige i dosta natezanja sa tim investitorima. Trebate zapravo odrediti iznos investicije koliko je neko spreman uložiti i ponuditi ili valuation cap ili discount. Doći ćemo do toga što to znači. Da li je safe siguran način investiranja? Pa namijenjen je da bude predvidljiviji i za osnivače i za investitore, trebao bi biti optimiziran za startupe u ranoj fazi i trebao biti standardiziran, dakle da se ubrza prikupljanje kapitala. Znači, pod uvjetom da postoji nekakav template, odnosno obrazac safe-a koji vam je dostupan i s kojim se slažete i koji vam odgovara. U tom slučaju možete relativno brzo skupiti zainteresirane investitore, svima im ponuditi taj dokument i oni bi ga zapravo svi trebali prihvatiti uz ove dvije odredbe, znači da se odredi iznos investicije i prednost za investitora do koje ćemo doći, odnosno valuation cap ili discount. To bi trebalo biti, kažem, zamišljeno da bude jednostavnije od convertible nota ili nekog drugog instrumenta. Inače, često se koristi ili u kolokvijalno se to naziva safe note, sa stajališta common law i, ajmo reći, Amerikanaca i engleskog, načelno ne bi trebao biti note, znači treba bi biti samo safe, odnosno onaj agreement, note ima neko drugo pravno značenje, ali mislim da kažem safe note, svi koji su u toj industriji će znati što mislite. Kako safe zapravo izgleda? Dakle, investitor daje novac u društvo i uz obvezu društva da izda, odnosno da udjele, ono što nekad se u dionice, ali u praksi će biti najčešće udjeli, kada se dogodi nekakav trigger event, odnosno neki događaj, neki trenutak.
Ja se ispričavam, ali kako je došla, pa sam da govori baš hrvatski.
Just switch in English.
Yeah, okay. Okay, so we'll switch it to English. Hi, nice. Okay, so the investor gives some money to the company, and the company promises to issue shares when this trigger event occurs. That means that a certain amount of time will pass until this trigger event, and then the investor will get some shares in the company. What do we need to determine initially? Again, we need to determine the amount of the investment, and we need to fix, this is usually already provided in the template, which benefit the investor gets. And of course, why does the investor get a benefit? Because he invests capital at a very early stage when there is a high risk of failure and actually losing the investment. The two most common types of benefits are the valuation cap and or the discount. And if you have those set, you're basically done. The rest of the document, including the legal stuff, should already be in the template which you decided to use. The template usually consists of those elements which are shown here. So the definitions, which includes the definition of the trigger event for the issuing of the shares to the investor. The description of the trigger event, which usually says equity financing, liquidity event, or dissolution of the company. Some examples are, the most common one is raising capital to issue shares, change of control, which means that you sell the control package of shares to a certain investor or partner. IPO, which is, everybody knows, is the initial public offering of shares, but I would say it's quite unlikely that it's going to be the next step after the safe investment. The IPO usually comes much later. Dissolution means that the company voluntarily decides to stop working. This is very rare. And bankruptcy, which unfortunately is not so rare, which means that actually you did not manage to earn enough money or collect enough investment to keep on going, and you have to file for bankruptcy, which means shut down the company and basically everybody loses money. Then there's the calculation of shares upon issuing, which means what are the investors going to get when the trigger occurs. And now there's a difference between pre-money saves and post-money saves, which means that it will be explained later, but there are two different methods of calculation which may have an impact on the percentage which the founders will get and which the safe holders will get upon the trigger event. There are the representation as the warranties, which is the, I would say, most legal provision, which those are basically, let's say, promises, or you as a founder, you declare and guarantee that your company works and exists in a certain way. These are necessary to prevent fraud mostly. So this is the idea that you say we actually do have a company and we do run our books in accordance with the law, etc. And then finally, there's the miscellaneous provisions, so-called boilerplate clauses, also legal clauses, but I would like to point out this applicable law and choice of court, which means that most of the templates which you can find online for free of the safe are governed by a law of a certain US state. It can be Delaware law, California law, whatever. The problem is that, of course, Croatian law is not very similar to the law of any of the US states, and I would never recommend anybody to signing up to say that your contract will be governed by the law which you do not know, because that means that if you have a problem, if you have a dispute, you will have to hire an attorney from that jurisdiction to help you and guide you to interpret the contract and lead the dispute. So hopefully we will soon have a Croatian template of the safe, which will say that Croatian law is applicable and that courts in Croatia will deal with any disputes. Hopefully not, because you know how courts in Croatia work. Here is an example timeline. So from the investor's view, so people invest some money in the safe, they sign the document, then a certain amount of time passes, and this is the idea of a safe, so it doesn't have a maturity. So this amount of time can be quite long. It will depend on the further development of the company. Then we have the big unknown, which means whether the idea succeeds, whether the company gains some revenue, whether there is interest for new investment rounds or not. And then there are basically two main possible outcomes. One is the trigger event, which has been described in the safe, which means that everything is good. The company succeeded in ensuring new financing or actually develops, and you finally get the shares which you have been waiting for. Or the worse and sometimes more common option is that actually the company goes bankrupt and the investor loses the money because the safe does not give you any, I would say, meaningful preference in case of bankruptcy. You basically come after the obligations of other creditors before the founders, which is usually zero. Okay, so going further through the standard terms. So what can the company do? How do they raise further money after they receive some investment via SAFE? So of course, bootstrapping is always an option. It usually does not have any effect on the SAFE because there are no obligations towards third parties. You can issue new SAFEs, new rounds of SAFEs under same or different terms, and it may depend. So again, depending on the provisions on the templates, etc., it may affect the earlier holders of the SAFE. I will come to that part in a moment. If you issue convertible notes or other instruments for further investment in the company, this can also affect the SAFE, which means that basically the holders of the SAFE may be diluted and maybe diluted more than they want. If you have a priced round or you issue shares, this is considered to be a trigger event for the conversion of the SAFE into shares. And of course, if you go to the IPO, which as I said, is quite unlikely at that stage, but this would also be a trigger event for the conversion of the SAFEs. Now the benefits which are offered to the investor. So as I told you, this is a very early investment tool or instruments, and the investors should be rewarded in a way. The usual ways are valuation caps, discounts, or MFN clauses. Valuation cap is something which protects the investor if the company value rises too much up to the trigger event. So this is something which you have to determine and of course negotiate with the investor. You need to set a valuation cap which is in a way reasonable and to find the right balance between the fact that the investor would like to get a multiple on the invested amount at the time when the SAFE triggers, which means he would favor a lower valuation cap, and you as a founder are going to push probably for a higher valuation cap because you don't want to, let's say, overcompensate the investor for the investment. The idea of the valuation cap, which you may already know, is that whatever the actual valuation at the time of trigger event, the amount of money which was invested by the investor will be converted into shares as if the share price, or actually the valuation, was only X. So if you put a valuation cap of 5 million and somebody invested 500,000, that means that they would get more or less 10% of shares. They would get 10% of shares even if the actual value or the valuation of the company at the time of price round was, let's say, 20 million. So they will get more than the later investors for the price. The second option is the discount, which also protects the investor. It has slightly different mechanics than the valuation cap, and it means that regardless of the actual valuation at the time of the trigger event, the SAFE investors will get the shares for, let's say, 20% or any kind of percentage less per share than the other investors, which means that in this case where it's 20%, they would get or they would get 20% more shares or 1/5 more than they actually invested. The third option which can be used, and also the valuation cap and the discount are usually mutually exclusive, so it's usual not to apply both of them. So you can maybe contract both of them, but then the investor should choose between using the valuation cap or the discount, whichever is more favorable. The third is, I would say, not mutually exclusive. It's an option which can be included, and the MFN means that the investors of the SAFEs will get the best applicable terms at the time of the conversion. So if the conversion goes under the terms which are more favorable for investors than at the time which they invested, which actually unfortunately means usually a down round where you did not manage to grow and get a higher valuation, then the SAFE investors would get their shares at those terms offered to the, let's say, investors who has been mostly privileged or who gets shares the cheapest. Then there is the difference between the pre-money SAFE and the post-money SAFE. So that's not quite the same as the pre-post or pre-money and post-money meaning in a financing round, because both of these distinctions, when related to SAFEs, they occur prior to the valuation or the calculation of the cap table which occurs in the price round. But the difference here is whether, let's say, whether one round or one class of safes will be diluted by any subsequent rounds of safes which you issue. So, as an example, you start and you issue safes for, let's say, $1 million. And if it's a pre-money safe, that means that the investors do not know how much percentage of shares or how many shares they will get at the time of trigger event. If you need more money and you need to collect more by subsequent rounds of safe, those other safes will add up, and actually they will add up, and they will all the rounds of safes will basically divide the same percentage, which means that if you had subsequent need for money, the investors would get less. Post-money safe, in effect, there are some, of course, details, but generally guarantees to a class of investors that they will get the percentage which has been mathematically calculated by dividing the valuation cap with the amount they invested. So if they invested 500,000 at a 5 million valuation, that means that they're more or less guaranteed to receive 10% from you. That doesn't mean that they will have 10% in the end after the entry of the other investors in the price round, but in the, let's say, the relation between you as a founder and them as the holders of the safe, they will get 10%. And yeah, I just put here that, of course, the new investment trigger event is always post money, which means it, in any case, will dilute the founders and the safe holders. So in any case, the safe holders after the price round will get less than the actual amount which they got at the time when they were the only investors in the company. But of course, their percentage, which is mathematically less, will hopefully be worth much more. So there's an example of the pre-money safe. Again, this example which I told you, which is, let's say, 10%, and the question was, will you get, as an investor, 10% at the trigger event? Not necessarily, because subsequent rounds of raising money, either by safes or other instruments, would dilute both your percentage and the founders as well. So if there are several rounds of financing before the trigger event, because not every financing will qualify as a trigger event, then the safe holders could find themselves more or less severely diluted. Post-money safe, which is now the prevailing standard because the Y Combinator, let's say the parents of the current safe have converted their template to the post-money safe some 6 years ago. As I told you, they basically guarantee the safe holders that they would get the mathematical percentage which is derived from the valuation cap and the investment amount at the trigger event, which means that the company can still subsequently issue safes and other instruments, but they do not dilute the holders of the previously issued safes, but they dilute the founders, which means that if this round is 10% of the company and you want to issue another post-money safe round, you will have to give out another 10% of the company, which then after a while can get quite, I would say, burdensome for the founders because they don't want to end up a minority in their own company. Some pros and cons of the safes. So for the company or the founders, they're meant to be quick to negotiate. That doesn't mean that in any case you will be quick to negotiate, because you can of course discuss a lot about the investment amount and the valuation cap, but still much less because the other provisions should be fixed. They can rely on a standard form, but as I told you, don't just download one from the internet. Be sure to understand it, and this is where legal advice is recommended. And I mean, like actual legal advice, not asking ChatGPT or just reading a blog. The third advantage is that no debt is created, no interest is accruing, no maturity date. So as I told you, this gives the founders a bit more breathing space to actually develop the company to a certain extent before taking the price round. And also for accounting purposes, it's good to have less debt on the company, because you may need to take on third-party debt like a bank loan at a certain point of time. So in that case, it's good to have less debt in your books. Of course, this debt will be junior to any debt in the investment phase is usually junior to the general obligations of the company, but still it's nicer to have less debt. You can raise several rounds of SAFE before the trigger event, which means that not every financing obtained after the initial rounds of SAFE will be a trigger for them, and which actually allows you to, if you miscalculated the amount of money which you need before the priced round, you're able to get some more money on the basis of SAFEs or convertible notes, and actually make sure that the company is running smoothly before everything triggers and everybody gets their shares. Also, I would say a conditional advantage, but a thing which the founders may appreciate is that there are no control rights, information rights, there is no formal influence by stakeholders. So they're not your shareholders yet, they do not sit there, they cannot ask too many questions, or at least you don't have to answer them, they cannot outvote you, they cannot veto anything, so basically they have to sit down for the ride and wait to see where it will take them, where the founders will take them. The cons, I would say that, of course, the effects of the SAFE on the cap table upon trigger event can be significant, so don't think of them as free money, because all of this may sound to somebody like, wow, it's for free, I don't give anything and I get the money, but it's not so simple. So it's still a legal obligation, and if you come to the situation where there will be a trigger event, if you get to the priced round, you have to make a nice calculation. So there are a lot of online tools to calculate the cap table, and it's something which you need to do because it will also, I would say, influence, once you take into the calculation the SAFE holders, any other holders of convertible notes, etc., then you see how much is left and how much is available for the investors in the priced round, and how much do you still have for your share options for the employees, and of course for yourself as a founder. So at the end of the whole process, you should still have much more than 50% of the company. For the investors, well, the pros should be that they're, again, quick to negotiate, so it's simpler and easier, and it should be like a one-stop shop, especially for the investors which are not so experienced. So in theory, this should broaden, I would say, the circle of people who could invest in a startup, because they don't have to know much, they just have to determine the amount of money they invest, and of course, agree with the founders on the valuation cap. It can rely on a standard form, but again, be sure to understand it. And it may offer more favorable terms compared to other instruments or later stages, because SAFEs are meant to be early stage financing, they're risky, you may lose everything, so you should be entitled to some kind of benefit, which means a favorable valuation cap or a discount. The cons for the investors, that it's not a monetary claim, except in maybe some, I would say, hybrid instruments between SAFEs and convertible notes. So it's not a debt. You cannot ask the company to repay what you invested. No interest is accruing, which means that basically your money is sitting at the same nominal amount, even being worth a bit less due to the inflation, and there is no maturity date. So as I told you, you sit and wait and see what happens, and you hope that, of course, the company will in time significantly increase in its valuation, and actually at the price round you will get much more value than the nominal amount of money which you invested. The cause is, if you opt for the pre-money SAFEs, that they can be diluted, and you may not know how diluted are you going to get, because you do not know how much money will the company need to raise before the price round, before the trigger event. And I would say the mirror or the flip side of what we said for the founders. So you have no control, you don't have information rights, you don't have any kind of formal influence. So you cannot say to the founders, look, I think you're going in the wrong direction, please do not pivot, do not drop this, idea or project. You can tell them, but they don't have to listen to you. And if the company goes bankrupt, they're actually effectively worthless, so they're next to the founder's equity. Even if you had a convertible note or something, you would probably not get anything, because in a bankruptcy the recovery rates are quite low. So, but just, you have to understand that actually the SAFEs are basically the last, or the ones that are almost the last in receiving any proceeds in a bankruptcy. So it's a risky investment. As a conclusion, they are a practical and comparatively simple instrument to raise money, which means that they should be more accessible to many investors and also more accessible to the founders. And they are, I would say, more relaxed for the company because they impose less of a financial or organizational or legal burden on how the company runs and how much time does it have until they go to a price round and actually convert. But as I said again, it's not free money, so this lack of obligations does not mean that there are no obligations at all. You will have to eventually convert them to shares, which means that they will be worth something, and you will have to, as a founder, give something, and probably at a moment where you will actually start to feel that your shares are worth much, because in a good scenario, which we had just a second here, so at the time of trigger event, you hopefully will get a much higher valuation of the company, and that means that you will have to go back to the valuation cap which was offered in the safe and actually give shares much below the current share price. And this may be a bit unsettling for the founders, but this is the price of getting the money early at those terms. Sorry, and you need to understand the template and use the right one. This is for everyone, for the investors and the founders as well. So don't just copy stuff from the internet, because there may be things in there which you do not understand and which may negatively affect you when the time comes. Use the cap table tools to make sure that you understand the final effect and result, and of course factor in all the money which you receive except bootstrapping and friends and family, which you don't have to repay usually, but make sure that after the whole event you still own enough of the company that you can run it the way you want. And of course obtain tax advice, because safes, I would say, are not very, they're not very common in Croatia at least, and I'm really not sure about the tax implications, so I would suggest that everybody get some tax advice. How do they affect the company? And even as an investor, you should get some tax advice to see when you are issued shares, how this will be, let's say, valued by the tax authority. And this especially is the case if you have foreign investors, which is hopeful, because you want to get people from other countries interested, but also you want to make sure that they will not pay high taxes on the safes. And this is more or less everything I had to say, so if you have any questions, please.
Questions?
Thank you, Tim, for your time and the presentation. So from the entrepreneur point of view, when will a safe instrument be, let's say, more advantageous versus, let's say, convertible bond?
Well, I would say, in my opinion, I think it's most appropriate at the very early stage. So like your seed or pre-seed stage, so you're really just starting up, you don't have the valuation yet, maybe you're still at the idea phase, you don't have a product, you don't have any revenue, and it's very hard to say, what the valuation would be in an ideal world, and you could spend a lot of time fighting about it. But of course you have some idea about how much investment do you need, and of course you have an idea what would be an acceptable valuation cap, so what percentage of shares are you prepared to give up in the future to get that investment at the very early stage. So I would say this could be the first instrument which you use to raise capital.
No, I need, thank you. I don't need. In the last slide, you mentioned cap table tools. Are there any actual tools we can use?
Well, yeah. I don't know any, now like by heart, which I can, recommend. But please, Google them, and you will find that there are some free tools. There are some which are paid, but if you like, it's $10. Use those $10 because you need to know, and sometimes the mathematics gets a bit complicated.
I actually have a link on an article that goes through how to use that table and has some templates that you can play around with.
Thank you.
That was something else.
Okay, so you mentioned that there are like many more cons in terms of investor, I would say, than there are pros. So in which situation investor will agree upon safe?
Well, I mean, okay, maybe numerically there were more cons, but that doesn't mean that they're worse than other instruments. So I think, let's say in an ideal ecosystem, you would have a standardized template of the safe, which would be more or less known to the investors and the founders. And then investors who just want, to take a dip into something or to invest in early stages, they would not waste time negotiating, etc. They would find somebody which would give them the, let's say, the perceived value ratio which they like, and then they go. So it's supposed to make investment a process which is, as I said, accessible to many people. So I don't think you are worse off, because again, in bankruptcy, if it happens, even if you have a convertible note, you will have, I would say, nominally more right to receive something, but in the end you will probably always get zero.
I have a question regarding the applicability of this to Croatian companies. Specifically about, is there a risk here that the tax administration treats this money as a loan? Because when you're a shareholder already, if the investor becomes a shareholder and gives a bunch of money to the company, then okay, it's a shareholder capitalizing the company, that's fine. But this is, in most cases, going to be a third party giving money to the company. VAT will not be applied to it, so it's not a good or service. And knowing the tax administration in Croatia, they're going to go, yeah, this is a loan, you should be charged interest, etc., and your documentation doesn't pay. So I'm not sure. Do you think there's a risk here? Do we need to maybe start talking with the tax administration as a community about this?
Yeah, definitely. I mean, there is, I would say, always a risk with the tax administrations in general. In Croatia, I would say even more so, because they have less experience, and there is, I would say, there is a bit of caution, if not fear, in the ecosystem and with the entrepreneurs in general about the tax authority and the way they apply the laws. So yeah, I would suggest that we talk to them if we ever. I mean, when we create a template, then I think we should discuss and try to explain to them that this is some kind of equity or quasi-equity, which is not supposed to be treated like a loan.
I have a question that's a little bit different perspective. So this is from university perspective, which would not be invested in early stage, but we want to leverage the value of the IP that was made at the university before the company was formed. So it will be like a spin-off situation where we would like to go for a license, but we would definitely want to have a wider return than a license, because license is linked to specific technology. And at the same time, we wouldn't really want to go into equity now, because we really would like to keep it light touch. And from that perspective, this looks attractive in a sense that yes, it would be sitting there, but it wouldn't have control and other mechanisms. But but it does then convert into real equity at the trigger event, right? So at the event of the sale, for example, as a sort of outcome for us, a technical or technology-based spin-off company, it would convert into equity, right?
Yes, with just a little, I would say, wording or caveat for Croatia, that it will not happen automatically, because we have still a very formal system for the limited liability companies, which most startups are, and actually to convert something into equity, you need a shareholders resolution, you need to go to the notary public, you need to register it with the commercial court, so there's certain steps. So there is no automatic, conversion or anything like that. So with this in mind, yeah, but the idea is, yes, sale is one of the events which trigger the conversion of the safe into equity.
Any more questions? Everything seems to be clear. Thank you very much, Tina. And you mentioned at some point we will have a template that we will also post on the web. But of course, as a disclaimer, the Tina already said, even though it will be a template that will be created for Croatian startup ecosystem, you still need to consult a lawyer to make sure that everything is as it's supposed to be. Awesome. Now it's the mingle time, so please join us in the back of the room. for some beers and pizza. Thank you.
Moram nešto uopšte govoriti, da im je prije plastiku, tako šta je to?